Hi guys. So we are going to be looking at the case background and the final pretrial hearing for Cordarra Tuitt. I want to make it really clear at the beginning of this video. I feel like people might be confused. Nicole Fegan is the defense attorney on this case. She's representing Tuitt. Adam Abbate is the prosecutor. There's also another prosecutor. I think her last name is Rivers, but I'm not too familiar with her. And it's going to be in Judge McBurney's courtroom. This is going to be a estimated to be 4-day trial. Abatte says that he thinks that it'll take him till Wednesday to present his case. And Nicole Fegan says we should be good by Thursday. So we should crunch all of this within this week. It starts at 9 a.m. Eastern tomorrow morning. We'll be watching it. And this stream is going to be short, but we're just going to look at the indictment. We're going to look at the pretrial hearing, which it's like 50 minutes long, but there's a lot of dead time that we'll skip through. And a little bit of background on, if you think maybe you've heard Cordarra Tuitt's name, he did come up in a Rice Street story. So we're going to look at that as well. With that being said, hello, everybody. So good to see Blue-Eyed Hillbilly. Hope you're doing well. Boop to FFS. Hey, Stephanie. Hey, Jimmy. Hey, Shanikia. So I think I don't know anything about what evidence they have. The docket was pretty bare bones. His original attorney was John Melnick. Now it's Nicole Fegan. I don't know if that had to do with, with Melnick. He had a 6-month suspension, so probably couldn't be representing people, and maybe they thought this would go to trial at that time. But here we are. So we've got this queued up. We'll take a quick look at the indictment. So, and I think this might be interesting. We're going to talk about something that we'll see here a little bit later in the stream. But if you notice here, we've got 8 counts. We've got murder. Then we have 3 counts of felony murder. So I'm like thinking to myself, all right, did we kill 3 people? Then we have aggravated assault with a deadly weapon. We have possession of a firearm during the commission of a felony, which is 16-11-106. And then we have 7 and 8. 7 is possession of a firearm by a convicted felon, 16-11-131B. And then count 8. Possession of a firearm by a convicted felon, previously convicted of a felony, should also be there, 16-11-133. So, and if we read quick, the best background we get from the indictment here is that the grand jury does charge and accuse Cordarra Tuitt with the offense of murder for the said accused in the county of Fulton on the 7th day of August, 2022. So, 7th of August, 2022. That's when this all happens. Did unlawfully and with malice aforethought cause the death of Quatavius Kawani Wright, a human being, by shooting him with a firearm. So that's the situation. The victim here is Mr. Wright. It was a shooting. This is the top count, count 1. And then we have these felony murder counts. How do they read? So felony murder, right? Felony murder means murder occurred while a felony was being committed, or the attempt of a felony. So if I rob a bank and, my intent isn't to go out there and kill somebody, but I'm running out the bank door with all my money that I just stole. I'm committing this robbery, this burglary of the bank. And someone outside says, hey, you stop. And then I turn and we get in a tussle and I kill them while I'm running away. Well, that's going to be, that could be felony murder. I didn't set forth my day to go out there and kill this random person, but because I was doing something else felonious and I kill them in the process, we're going to attack it with felony murder. And there's been a lot of discussion that prosecutors like to use felony murder because it gets them away from having to prove the elements required for malice murder. So pin that a little bit. We get to this count 3, which is the second felony murder count. Same day, same time, same victim. What's the difference? Well, the predicate act, the underlying felony that makes up the elements to make this felony murder. So what is that what is that predicate act? Well, it's possession of a firearm by a convicted felon as alleged in count 7. So this is the 131B. So here they're using 131B as the predicate for felony murder. Likewise with count 4, this felony murder count, same date, same victim, but here they're using as the predicate act, possession of a firearm by a convicted felon, as alleged in count 8. So 2 of these felony murder counts, again, one murder here, 3 felony murder counts, and 2 of them are relying on predicate acts of possession of a firearm by a convicted felon, and possession of a firearm by a convicted felon, previously convicted of a felony. So we're gonna hear a small mention of this in pretrial in the hearing. Nothing too spicy, but we're gonna look at some Georgia case law when we get there. So that's the background on the indictment. If you think his name sounds familiar, and let me close this. We're going over to this article. It's really from WSB TV, but it's syndicated by Yahoo here, but it's Michael Seaton. He does a lot of coverage on stuff that happens at Rice Street and the Fulton County Courthouse for Channel 2 Atlanta. This is an article from 2023, right? So let's rewind like 2.5 years. Lots of stuff was going on with Fulton County. That was really the first time period where I was getting wind that people are shanking each other with parts of the building because the building is just falling apart. Well, back in February of 2023, one of those attacks, there was an attack where 2 inmates had to be sent to the hospital with stab wounds. And one of those victims was Tuitt. So at the time, Tuitt was 33. He was rushed to the hospital after getting stabbed multiple times. Both detainees had been released from the hospital. They're recovering at the jail, which does not sound like a great place to recover. And I don't know any updates on this. I didn't see anything that came up under Tuitt's name. But at the time, a spokesperson for the sheriff's office told Channel 2 that the attack was currently under investigation and multiple people could face charges. So, and if you weren't aware of the statistics, so this is a February 2023 article, and it says here that Channel 2 at this time had learned that Fulton County Sheriff's Office has investigated more than 150 stabbings or attempted stabbings inside the jail since May. So in a less than 12-month period. Yeah, so... So I think that's the wrap up. We have a little bit of case law we're going to bookmark until we get to a relevant point of discussion. We're going to look at some case law about predicate acts for felony murder, Georgia case law. Other states don't do it this way, and this is something that came about in July of 2025. I think prosecutors love it. I think we're going to not love it. So captions are on. Let's do a volume check. We'll get into playing this. You can see Abatte and Fegan are here. They're alone at their respective tables. Mac in the building says, whatever happened to Nicole's charges? They've been pending. So just in case anybody missed it, Nicole Fegan was arrested like 1.5 years, 2 years ago, almost at this point, for potentially telling a suspect that, hey, they're looking at you. She gets out. She's bonded out. Attorneys aren't happy that happened to her. That case sits kind of in just like prosecutorial purgatory for who knows how long. And then all of a sudden, like a few months ago, maybe like 4 or 5 months ago at this point, there's an indictment that comes down that involves Nicole Fegan, Tinquarius Mender, and Tinquarius Mender's girlfriend, fiance, someone with a relationship to Tinquarius Mender. But she was the individual that was, since Mender's in custody, as a family member, was communicating with attorney Nicole Fegan, and they're accused of coordinating to bring contraband into Rice Street. I don't think there's been movement on that quite yet. So, which, I don't know. They seem to love to have things take a long time. Mr. Big Play braces, please look at this. It's very interesting about Fulton County judges again. So if you sent a link, I cannot see it. So I just see only this comment and what's showing on the screen. Nick Starro in the building. Nick Starro hears Fulton County and comes running. Good to see you, Nick. Just Shamrock, good to see you. Ashley, good to see you. Factual Lie is here in the building. Factual Lie was already planning to watch this trial, so I wouldn't have been surprised if I hopped over to like Judge McBurney's stream and saw her in the chat. Hey there to Kenya. Hey to Peter. Who else we got? We got Dizzy in the building and Tay Biz. We got the Z's going. So let's see. Let's see. Let me know if you need more volume. We'll start it a little quiet just in case it's loud. And we can speed it up a little. There is a lot of dead air.
Excellent. Ms. Rivers is here. She'll be out in a sec. Why don't we get her out and set up before we bring Mr. Tuitt out? Okay. Is he doing the Mr. Thug turtleneck thing? As in, I'm just not remembering his name.
Oh, look at Nicole, like, what? Mr. Thug. So he's talking about Young Thug and how he would have his court attire. He'd be wearing the turtlenecks with the collar, sitting over there at the table with Adams and Steele.
Williams, Mr. Williams is the turtleneck thing. Yeah, not Thug as in a bad guy. I didn't mean it that way, as in Mr. Williams.
Just iconic.
At least it's kind of fall now. It was kind of chilly. It's a little weird when we're in June and someone trots out with a turtleneck. People are like, huh, I wonder what's up with that. Oh, they? Yeah. Yep.
The infamous thermostat.
We're getting you a helicopter. Yeah. I like the haircut.
Thank you.
Get situated. Take your time, and then we'll bring Mr. Tuitt out and we'll get rolling. I gotta go get one thing. A certain JQC report and recommendation comes out today, so I need my phone in my.
Oh, Bray, is that actually what you're talking about? The JQC recommendation? Oh, that might be what Bray's talking about in the chat. Hold on, let me give you a wrench, Bray, because then you'll be able to post a link and YouTube will actually let it come through to the rest of us. I gotta jump over to my YouTube, not my StreamYard, to do that. I wonder if that's what you're talking about, though. Because that'll be cool to look at. And JQC, guys, is Judicial Qualifications Commission. So they review, like, judicial issues. If you guys remember, was it Christine Peterson? They recommended the removal of, I think it was Christina Peterson, after she was messing with probate cases and, you know, letting her clerk only inform one party of court hearings. And what really went viral about that judge is she was arrested while she was out at a club one night. But the review, that wasn't part of what the Judicial Qualifications Commission reviewed. But I think that's the most recent example. If you guys remember that story, that was JQC. So, and then Bray, okay, let me open this. Let's see, I think, put this over here. Ah, there we go. I think this is exactly what McBurney just said. Bray is right on time. So let's jump over here. We just heard McBurney saying something from the JQC is about to come down. Yeah, this is it. Shout out to Bray. So this says, and again, this is channel 2, so shout out to them with all the coverage. State panel, and this is annoying. Let me put this in reader only mode. Because this banner at the top is sticky. It's going to cover the screen the whole time we're reading. All right, so this should be more visible. So state panel says Fulton judge should be thrown off bench for illegally jailing a witness and more. So this is Judge Shermella Williams. Was this there was a recent trial. I don't remember watching a lot of it. But I feel like we recently watched something with her. So Judge Shermella Williams, panel says she illegally jailed a witness, lied during testimony, and more. Oh. A state panel says a Fulton County Superior Court judge should be thrown off the bench. The panel said Judge Shermella Williams illegally jailed a witness, lied during testimony, and more. The 3-judge panel from the Judicial Qualifications Commission accused Williams of more than 30 counts of misconduct. They say they had little option but to seek the ultimate sanction after they said Williams violated multiple rules stretching back years, including finding that she lied on the stand. Given the level of untruthful testimony Judge Williams offered throughout, we are left with little option but to seek the ultimate sanction of removal. A judge that cannot be trusted to tell the truth cannot be trusted to remain in office. The JQC said that although she often handled a heavy caseload, some cases went years after the final hearing without rulings. Can you imagine being in limbo after having your case, not just waiting to have your case, but all your laundry gets aired out in court, right? We sit here, we watch your issue over here on YouTube. We go down in court, all your laundry's aired out, we're aware of it. And then you don't even get a decision. And I think it reminds me of Jim's dealing with an issue where, there's an individual who's incarcerated right now who's had trouble getting transcripts from his trial because the first judge passed away and then the second judge was there and then was not on the bench anymore. And it was like this whole staircase trickle effect of like the person that you have to ask to issue an order for the court reporter to issue the transcripts from your proceeding. They're not there to make the order. They keep switching and keep moving and not responding. So really, really not good. Oh my goodness. So let's see. How is it anyone's fault but yours? One judge asked Williams during a hearing this summer. That's not what I'm saying. I'm being very transparent and candid, Williams said. According to court documents, at least one case did not get a final ruling until 29 months after the final hearing. Jesus, that's like 2.5 years. The panel says the long wait times were the least egregious of her problems. The JQC found that Judge Williams had improper ex parte conversations with one person about the case because they were sorority sisters. In another case, the JQC found she improperly helped a family member. What's sorority, guys? Who's the sorority sister? Who's the person? Because I hope it wasn't another prosecutor. And we have a quote here. Judges not only have to do the right thing, they have to avoid even the appearance of impropriety, Randy Kessler, a prominent family law attorney, said. Kessler has tried many cases in front of Williams and says she was often a good judge. I've seen her hundreds of times try her best to get it right, Kessler said. I don't think Judge Williams was trying to do wrong if she did make mistakes. However, the JQC said in the most egregious case, Williams improperly jailed a witness. And this was another, I believe this was another issue that, again, they had like 30 grievances that they looked at here, but they're focusing on what seems like 5, 6. Same thing with Judge Christina Peterson Patterson. They really did not like that she jailed a witness. Like, you're taking away someone's freedom and you're not doing it for a proper basis. That's very egregious. So they take issue with that here in Williams' case as well. They say that while a 21-year-old witness testified on behalf of her mom, Williams constantly interrupted the testimony and asked her questions. At one point, she allegedly commanded the deputy put the witness in custody to, quote, go show her what that cell looks like. All right, and Williams' response, why did she do that? She said, I was trying not to put her in jail and essentially say scared straight for a better term. That was not the right decision, Williams told the panel. I think I've seen it all, right? And then I see something like that, Kessler said. The commission found Williams seemed to constantly change her story on the stand. The recommendation will go to the Georgia Supreme Court, where they can accept the recommendation, reject it, or provide their own decision. So there we go. We just heard McBurney mention this report coming down, and Bray shared it with us, so big thanks again to Bray. And let me go back to the Channel 2 link, in case you guys missed it. This is the link that Bray shared. There we go. And I see we have two Nicks in the building. We have that guy, Nick 36. Nick uses the numbers to make sure we don't get it confused. And then I saw that you moved. So I hate moving, you guys. So congrats on moving. Congrats on moving. I hope it was an easy move. I hope your back's okay. And that you're enjoying the new place. And I'm glad you're hanging out with us today. And then let's see. Let's get back over. I think they have a little bit more conversation here, and then we can jump ahead while they're getting Tuitt out. Nope, just small talk. Okay. Let's look to when they peep their head out. Okay, right here.
So he's enjoying his sort of a built-in set of friends.
Yes, that's nice.
Hey, Mary.
So he's at the gym a lot. He claims he's going to class.
I'm sure he is.
Yeah. I don't worry about him too much on that front.
And we put all the questions in.
Okay.
This is your notes for 1 through 16,
Okay.
and then that's your draft. Okay.
All right, you ready? Okay, we're going to get on the record in 22 SC 185328, State versus Tuitt. Mr. Tuitt is here. Good morning, sir.
How you doing?
I'm all right. Good to see you. He is here with his lawyer, Ms. Fegan. We have Mr. Abatte here for the state. Today is jury selection, but before I order up the jurors, we need to work through two things. Mr. Tuitt, I'm sure Ms. Fegan has told you about a development on the professional side of her life. She's been indicted in Fulton County for certain allegations. They are purely allegations. Ms. Fegan sits next to you and in front of me with a presumption of innocence in her favor. But the fact that the Fulton DA's office is pressing charges against her creates an appearance of a conflict. One observer could look at this and think, well, maybe Ms. Fegan might not fight as hard for you because she doesn't want to upset the district attorney's office. I'm not saying she would ever do that, but I need to make sure, one, you're aware of the general situation she finds herself in, and two, assuming you are, that you're waiving any potential conflict, that you're not concerned that Ms. Fegan might push a little less hard on your behalf because she doesn't want to upset the office that is prosecuting her. So let me break it down into two questions. Are you aware of the situation in which Ms. Fegan finds herself?
Yes, sir.
Okay. And are you comfortable proceeding with her as your lawyer in this case?
Yes, sir.
All right, we'll do that. I don't plan on bringing that up again. The jury's not going to hear about it from me.
Okay.
But I need you to let me know if halfway through the trial, you're like, wait, you told me you were going to do X. And then I heard the prosecutor say, hey, we'll go easy on you in your case if you do something. That's not good.
Do you see the example he gives? Do you see the example? He gives the example of the prosecutor doing a wink, wink, nod, nod.
For you. I don't see that happening. That's not how Ms. Fegan
Hey, Chad.
works. But I'm going to rely on you to let me know if you develop a concern about this theoretical conflict. Okay?
Yes, sir.
All right.
And
Mr.
what do you guys think? My personal opinion is I don't picture Nicole Fegan wanting to go easy on the prosecution because she's facing charges. My guess, my judgment, my read on Nicole Fegan based on, limited, we've seen mostly pretrial, like outside of actual trial proceedings, a little bit here and there with Nicole Fegan. But I've watched a lot of her case updates. She's scored clean acquittals for murder, gang charges, 28 count indictments, clean not guilties across the board. She is a beast. I think she is a beast. And I do not think that she's going to be like, oh, I'm going to be a bad advocate for my client. Please spare me. Please show me mercy. I think it's quite the opposite. So if I was Tuitt, I'd be like, this is fine. We're good. I'm sticking with it. With the exception of, could her proceeding take place and could it interfere and drag out my trial? And I have to wait another 2 years in Rice Street? Maybe that would be a factor, but that's different. So what do you guys think? Would you rather have an attorney with fire under their behind against the prosecution, or do you think that she's gonna cower and fade back?
What is the state's offer, if there is one, if Mr. Tuitt wanted to resolve this case by way of a plea this morning?
This one would be the minimum of life.
Okay, pleading to the indictment?
Yeah.
There is a recidivist notice filed that would be withdrawn for purposes of the plea if he did plead? Okay, so Mr. Tuitt, as I understand it, if you wanted to enter a plea today, you could, but you'd be pleading to the indictment, which means pleading to malice murder, which means the lowest sentence I could give you is life with the possibility of parole. Do you understand what the state's offer is?
Yes, sir.
They also would be withdrawing a recidivist notice that has the effect, if they've got all the right paperwork, of meaning that if you are found guilty after trial of murder or felony murder, that I would be required by law, regardless of what I thought about the strength of the state's case, to sentence you to life without parole. Do you understand that?
Yes, sir.
Okay. Understanding those things, are you interested in pursuing the state's offer? In other words, entering a guilty plea, knowing that it's a life sentence?
No.
No, you'd like to go forward with trial?
Yes, sir.
We will do that. Ms. Nelson, if you could order up the jurors, please. We've got some other things to talk about, but the first thing I'd like to do now that we've ordered up the jurors is have everyone sign the indictment. Two things about the indictment. One, Ms. Fegan, this is a copy. It's not the original, but it's an exact copy. Are you okay using this document as the thing that everyone signs to indicate the not guilty plea and the joinder of issue?
Yes, sir.
Okay. In a minute, we're going to talk about redactions to the indictment because there are a couple counts that indicate not just that Mr. Tuitt is a convicted felon, but it gets into some of the specifics. But let's sign first, please. Thank you, sir. So let's start with that question of redaction, and we don't need to get into the specifics right now, but are you requesting, Ms. Fegan, that it would be count 7 and 8? Count 7 is possession of a firearm by a convicted felon, a 131, and it has the specifics that Mr. Tuitt allegedly was convicted of a felony in Cherokee County, and it says it's entering auto. That's not child molestation. You and he may not mind that the jury sees it's entering auto, but do you have a perspective on whether?
And I feel like I need to pause and clarify. This is Judge McBurney just saying it's not child molestation. Nothing with this defendant has anything to do with any type of SA or child abuse. McBurney is simply saying, hey, it's only theft of auto. It's not something that's so taboo, so stigmatizing that's going to inflame the jury. Right, to show the jury the indictment, the element language in there. That's what he's saying. I just wanted to stop and clarify that mention of child molestation, literally nothing to do with this defendant. Just an example pulled out of thin air.
There should be any redactions in count 7. Or you want to think about it? It's on your radar now.
Yeah, I'd like to think about.
I won't be reading.
The felony murder also, so to a possession by convicted felon.
Right. So the only thing that would be redacted is the nature of the offense. I don't think, I'll hear you out if you disagree. I don't think there's any bifurcation here because it's a felony murder count. It's solely the question of whether count 7 basically says he's a convicted felon and doesn't talk about entering auto, because sometimes that other felony is a messy one and you understandably don't want the jury to know, hey, he shot someone before, and they'll draw their own conclusions. Just keep it in mind, because on Monday morning, I will be reading the indictment to the jury, and I'll need to know if you are asking that I simply say he'd been convicted of a felony in Cherokee County in September of 2021, because that's sort of what the redacted version would be. It just wouldn't say what the felony was.
Yes,
That's not a material element. Similar question well, actually, as I look at count 8, it doesn't say what the underlying felony was in the 19 SC case in Fulton County. It simply says that it's a felony involving the possession or use of a firearm, which is one of the elements of 133. So I don't know that there's anything that needs to be redacted from count 8, but if you would, between now and Monday morning, just be thinking about whether you want in either of those counts, 7 or 8, anything redacted, then I'll know what I'll be reading to the jury, and we can edit the indictment so that what goes back with them doesn't have the objectionable language if I find that it's objection.
Yes.
All right.
So I don't know if we'll get to hear that tomorrow morning, if they'll be in court to argue it, or if they'll handle it through like correspondence with the court. But I think this is a good time to pivot over to What I think is the prosecution's dream case law. So, we're going to look at Adams v. State. This was decided earlier this year, I think July 2025. We're going to take a look. But first, happy birthday to Lay. She says, hey, spending my birthday catching up with Fulton County nonsense. Yeah, and this is a bit of a double feature thanks to Bray letting us know about the JQC report. So happy birthday to you. Hope you enjoy it. Don't let Fulton County bring you down. Oh, man. And I would do the same, like spending my birthday watching train wrecks and, you know. Although this proceeding is going smoothly. So, I'll hold my breath, though. So, this is quite long. So rather than read this on stream, there is a case mine summary. And it's broken down in what I think, I had to take some time to digest what was being said. I looked over at some case law in North Carolina to see how North Carolina does not permit prior possession felony convictions as a predicate for a later felony murder. But in Georgia, they're going to allow it. And this summarizes the holding from this 2025 case. So Adams v. State, decided by the Supreme Court of Georgia on the 1st of July 2025, presents a multifaceted challenge to a felony murder conviction predicated on possession of a firearm by a convicted felon. They're going to abbreviate that to FIP, felon in possession, FIP, felony murder. So anytime we see this phrase, they're talking about a felony murder charge with the underlying felony being this possession. The defendant, Xavier Adams Jr., appealed his life without parole sentence for the shooting death of roommate Sean Peterson. Adams raised 5 principal assertions of error, the most significant being that 1, the conviction for felon in possession, felony murder, we're going to call it FIP, should have been vacated under the Edge modified merger rule. We're going to learn more about that below. In light of the jury's simultaneous verdicts of voluntary manslaughter and felony murder predicated on aggravated assault. So in this case, 1 murder, 1 victim, jury convicts them of both voluntary manslaughter and felony murder. The verdicts were mutually exclusive. The trial judge impermissibly commented on the evidence, and the trial court's jury instructions and its response to a jury note were plainly erroneous for omitting a proximate cause explanation. So other issues were raised in this appeal as well. Let's see. This Edge rule. The court affirmed the conviction in full, thereby setting 2 principal guideposts for Georgia criminal law. So maybe in future cases we'll hear this cited. We'll hear this argued. It reaffirmed unequivocally that the modified merger rule of Edge v. State does not apply to felony murder premised on possession of a firearm by a convicted felon when that possession is independent of the killing. And this is going to sound, I had to really look at this and wrap my head around it. The way they break it down is just, and then 2, it offered practical parameters for plain error review, emphasizing both the need for on-point controlling authority before an appellate court will call an omitted jury charge clear and obvious error, and the effect of affirmative waiver when counsel explicitly approves the trial court's actions. So, I think the prosecution, Fulton County, they and other prosecutors in Georgia probably love this this decision, this holding here. Also, Amy, good to see you. Happy Sunday to you, Amy. Thanks for hanging out with us today. Amy's link is in the description of this video, you guys. You will never run out of body cam video to watch. Tons of content over there. And again, some of it's crazy, but some of it is pretty humorous. So it can be some light watching for a Sunday. Good to see you, Amy. And let's break down these details. I'm glad Case Mine has this because reading it through the actual decision, it was a lot to digest. So, summary of the judgment, the Supreme Court rejected each of Adams' 5 enumerations of error. We're going to look at these 2 here. So, the modified merger rule. Because Adams' firearm possession, so the underlying felony, was independent of the killing itself. They're not saying you possess, and this is the same thing that we're going to be looking at with Tuitt. The 3 felony murder counts, 1 is ag assault, which ag assault would relate to, you could relate to, you know, the weapon you have at the time, the firearm that you're actually using. And that's really, adding that count in gives you a way to get to murder without getting to malice murder. The other 2 felony murders that we're looking at for Tuitt involve an underlying predicate act of a prior felon in possession. And I think it's like a 2017 case that they reference. So, here, in the Adams case, because his firearm possession, the predicate acts were independent of the killing itself, Edge did not compel the court to vacate the felon in possession felony murder count. So, if they didn't hold this, the opposite decision, and what North Carolina would do, and what seems to have case law for, would say, look, because the jury, it's an incompatible verdict. North Carolina would look at this as being incompatible. The jury cannot simultaneously, for one act, find that both the elements of voluntary manslaughter and then felony murder can coexist. It's an incompatible verdict, so we've got to vacate. But here, Georgia finds a very different way to look at it. So the voluntary manslaughter verdict merely barred felony murder predicated on the same mitigating assault, not on an unrelated felony such as felon in possession. So if it's using these prior using 131 and 133, which involved a prior conviction, allowed the double verdict to survive here. And can you see why this might be Fulton County's dream? We're going to charge multiple felony murder counts, and we're going to tack on these prior possessions, because even if this individual, the jury doesn't think they did XYZ, it wasn't malice murder, and it wasn't felony murder for the underlying felony that happened at the same time. They're a convict and they had a gun on them. We can get them that way. So 2, no mutually exclusive verdicts. Voluntary manslaughter requires an intent to kill under passion/provocation. The felony in possession felony murder requires only the intent to possess a gun. The 2 mental states do not logically negate one another. So this is where they make the distinction, this mens rea. All it takes, all Georgia, this case law, this precedent sets, felony murder and voluntary manslaughter, they don't contradict each other because there's different mens rea, different mind states. With felony in possession, if I intended to possess a firearm, knowing that I have a prior conviction and I'm not supposed to possess a firearm, that's enough to get a jury to say, yep, elements are there for felony murder. Do you see why this is Fulton County's dream case law? And Fulton County prosecutors can't get 131 and 133 straight. I think it's going to be such a confusing question to ask a jury that there's a strong likelihood that jury could be like, he had a gun, guy died. And this sheet says we can convict him because he had gun and guy died. So yeah, and these deal with the other issues here. They do cite, I think this would be worth reading. We'll read the ones that, these seem to all relate to Edge. So this is the analysis that CaseMind put together. So Edge v. State, which involves the merger, if there's, these overlapping or incompatible verdicts. So Edge v. State is what established the modified merger rule, barring felony murder convictions when the underlying felony, typically aggravated assault, is the same act mitigated to voluntary manslaughter. That's what makes it incompatible. If the jury finds that the underlying thing is mitigated, well, then we can't just use that to, it wouldn't make sense. But Adams argued that this rule should extend to felony and possession murder, and the court disagreed, finding the possession independent and not susceptible to passion provocation mitigation. We've got Griggs v. State, this is 2018, clarified that Edge is triggered only where the underlying felony is, quote, equally integral to the homicide and susceptible of mitigation. The court relied on Griggs in labeling felon in possession an independent felony. So basically, if the jury says voluntary manslaughter, it has no bearing on their ability to hold weight in terms of the murder count, the felony murder count. DuBose v. State, Amos, Wallace, Lawson, Sims. So a few cases here that seem like they might cite each other. a line of Georgia authority uniformly refusing to extend Edge to felon in possession felony murder. So there's a lot saying no. We don't. There's all these cases that no, we don't want to allow this 131, 133. We don't want to allow prosecutors to use that as a predicate act for felony murder. But here, in Adams in 2025, the court invoked these precedents to underscore stare decisis and deny Adams' requested extension. So this is a big change, particularly because we see how much these felon in possession counts are added into future indictments. McElrath v. State defined mutually exclusive verdicts, so guided the court to find no logical contradiction between voluntary manslaughter and felon in possession felony murder. State v. Williams 2020 and Hill v. State. We've seen these. I think we've seen these recently. Provided the 4-part plain error framework. The court used those to evaluate and reject Adams' instructional. Yeah, so I think Jim cited Hill recently. I think the state and Tiffany Adams and Jim are arguing about the holding of Hill v. State. And Love misinterpreted the holding in Hill v. State. And it doesn't support her argument. So this is a familiar case here. This is dealing with a different enumeration of error. And same here. Now let's look at the legal reasoning of the court. Let's get this summary here. And Aaron, if you want, I'm sure you already pulled it up if you wanted it, but Aaron, this is the Justia link to the actual decision, since we're just looking at the quick summary. All right, so the court's opinion may be distilled into several doctrinal syllogisms. So we're only going to look at, I think, these two. So premise 1, the modified merger rule. Edge applies only when the underlying felony is the mitigated assault itself. So if they're not mitigating on the other, so again, for Tuitt, the case we're going to be looking at this week, there's 3 felony murder counts for the same victim, same murder, same incident, same transaction. They're saying here, this court decided that Edge, when we would have to merger, if this jury were to say like, well, we actually are going to mitigate it down to a lesser. Well, if they're only mitigating it down to one of those, but also find, well, yeah, he had possession and a guy died, so we're going to do felony murder. We're going to mitigate on the first felony murder count with the underlying assault. But we're going to say yes all the way, top level, on the felony murder with the underlying possession. This court now says that can't merge that together. Both verdicts can stand. Premise 2, possessing a firearm as a felon is not mitigated by sudden passion. Its criminality exists irrespective of provocation. The logic here being that if you're not supposed to be in possession, it doesn't matter what happens today, tomorrow, or the next day. It doesn't matter if anything happens or not, anything exciting, if you have a boring day. You're just plainly, purely not supposed to be in possession of that firearm. So, no way to mitigate that by saying, well, things got hot, things got heated. And then their conclusion here is felony murder based on felon in possession does not merge and remains valid. And then mutually exclusive verdicts. So voluntary manslaughter, intent to kill, and provocation. Felony in possession murder is intent to possess gun and death results, with no malice, intent to kill needed. So this is what it boils down to. This is a very powerful avenue that is now held by this court. It's precedent. This is the Supreme Court of Georgia, that you can get to a felony murder just because somebody had intent to possess a gun generally. And some other thing happens and a death ends up resulting. You have those two things happening at the same time, even though they're not related. I'm not intending to possess a gun because I'm planning for this death to occur. I just have this gun and I'm not supposed to have it, and somebody dies. Like, this to me boxes in what could be immune from prosecution otherwise. If somebody is in the right to defend themselves, but they're not supposed to have a gun, there is no longer self-defense. This is what I see being like, I don't love it. I don't love it. I get the idea. You're not supposed to have a gun. I think you should still have to prove that somebody murdered somebody, and then also that they had a gun when they weren't supposed to have a gun. Charge them with those two respective counts. But creating this like new void, filling a void over here, that gives you an extra layer to prosecute, where now you don't have to prove beyond a reasonable doubt that, because aggravated assault can include, you have a gun, maybe you brandish it, you threaten somebody with that weapon, you fire that weapon, you discharge that weapon. That aggravated assault is in relation to that same firearm that you're also having a felony murder count with an underlying predicate act of being in possession of that firearm. It just seems like an unfair overlap. And I think there's a reason why we have all of these cases that are like, no, we don't want to extend it that way, until this court comes along and says, you know what? We're going to extend it that way. So, a lot there. I'm going to link to this in the chat if you want to read it again, digest it again. This is the summary. But yep, 2025 case law there for the state of Georgia. And we'll jump back over to our pretrial hearing. Actually, quick look at the indictment. Again, if you're tuning in late, this all relates to one murder. But we have the top level murder count, which you have to have. It's malice, aforethought, the intent has to be there. The felony murder, which we know it's a lower hurdle for prosecutors to get to felony murder, because jury doesn't have to think I sat for a week and planned to go kill somebody. They could just think I was like wrangling around, tussling with somebody, and I took it too far, causing their death, and I'm responsible for their murder now because my fight with them, I didn't plan to kill them, but I did. It's a lower burden, lower hurdle. But then we have these other two. These are the ones that relate to count 7 and count 8, the possession of a firearm by a convicted felon, 131. And I feel like, Aaron, am I tripping? Or is count 8, possession of a firearm by a convicted felon, 133? Shouldn't that also say previously convicted? Shouldn't it need to say in the caption? Because they have after having been convicted of a felony and indictment, a different indictment down here. Oh, that's 7. Wait. Yeah, they have it written down here. But here it's just kind of naked and not spelled out. So let's get back to this this pretrial hearing. They just they're going to get back to the judge on Monday, the defense, to say, are we going to request any redactions with the wording of the indictment? That way the jury is not reading something that could be unduly inflammatory or prejudicial.
All right, Mr. Abatte, anything you want to add on redactions? Okay. Mr. Abatte, you mentioned when you and Ms. Fegan and I were talking last week that you think that the state's case will run into Wednesday, might be done then. And even when I said, gosh, Wednesday is a sort of a half day because of drug court, you thought you still might be resting by Wednesday. Any change to that estimate? Okay. I'll probably try to qualify the jury for the whole week, but let them know that we think we'll be done on Thursday with everything. Does that fit with your estimation as well, Ms. Fegan?
Yeah.
All right. I now have a witness list from the state that has been reduced to those who will be called. You have a copy of the witness list, Ms. Fegan? We'll get you a copy in a moment. Hopefully there are not any names on there that are surprises to you. I don't have a witness list from the defense. Other than Mr. Tuitt, is there anyone why don't you flip through that list first? I just need to know if there are other names I need to qualify the jury with.
Look at Abatte struggling with the string to close his binder up. He's like tangled.
Is there anyone why don't you flip through that list first? I just need to know if there are other names I need to qualify the jury with.
He just gives up.
No, no.
Okay, then that's the universe. Mr. Abatte, you'll have Monday morning exhibit lists for us?
Yes, Your Honor.
Great. Let's talk about jury selection. I emailed you all the proposed general questions that I'll ask the 51 jurors who will be coming in a little bit. Did the state have any additions or subtractions?
There you go.
Ms. Fegan, did you have anything you wanted added or removed from that list?
No, Your Honor.
Okay, sir.
So the witness list in the indictment was short. I don't have an updated copy of a witness list, but it was just like 2 detectives, 2 investigators. But I'm sure it's longer than that. But again, this is only going to be like a 2.5-day case presentation by the state. And then Fegan's not calling any witnesses. So, at least I don't think so. And then Nick here in the chat says, how is felony murder different from manslaughter then? Manslaughter is like an accident. So manslaughter is like heat of passion. And there can be voluntary and involuntary. But with felony murder, I think the easy way that I compartmentalize it and think about it is felony murder, you have intent to commit the underlying felony, right? So the intent aspect for felony murder is relating to the predicate act. You intended to go and get back and fight somebody because they stole your jump rope. I don't know. And then you kill them in the process, right? So the intent there is baked into the predicate act when it comes to felony murder. Whereas intent with a voluntary manslaughter is maybe I'm heat of passion. So, and I think that's where I think like the cheating, the infidelity, you catch someone in the moment and you just like kill them in that moment. That's voluntary manslaughter because it's not like you're accidentally choosing to kill them. You're choosing to kill them in that moment, but you were provoked in a circumstance you wouldn't normally be of sound mind in. So, yeah, I think the intent, where the intent happens with manslaughter, the intent is to actually do the killing for voluntary manslaughter. And then with felony murder, the intent is to commit the underlying predicate act, and that predicate act coincidentally proximately causes the murder, the death.
Easy today. Motions. There were no motions that I found in the docket. I will flag for the state that one Mike Carlson in July of 2024 filed a recidivist and aggravation notice. None of the cases listed on that are the cases in the indictment. So I don't know what Mr. Tuitt's on notice for as to what would be the basis of a recidivist status. Well, I do know. The only thing that's been filed, it involves 3 12SC indictments. It doesn't include anything from outside of Fulton, and it doesn't include this 19SC case that is in count 8. So I don't know if you've supplemented that with Ms. Fegan or how you want to manage it. I just want to put that on the state's radar. Should we get to sentencing, that the recidivist notice didn't include the cases in the indictment.
Look at his face. And they said Mike Carlson filed the thing in 2024. But what they're saying here is, Tuitt needs to be on notice to defend himself and be aware of the risk he's facing, not just to defend himself at trial. But we heard at the beginning of this proceeding that the plea that was on the table, it wasn't that much of a plea. It was, you're going to plead guilty to everything on the indictment, all 8 counts. But we'll remove the recidivist notice, which could change the terms of his sentencing. It was still life on the table, but maybe it would change his eligibility for parole, things like that. And this recidivist notice, this recidivist filing, doesn't contain everything that I assume that it's the recidivist notice that's lacking, right? And that means it's not including these acts. So where was the case? So count 7 cited 19 CR 0262 and count 8 cited 19 SC 171734. So the recidivist notice isn't including these things that happened before the recidivist notice was filed. So this is 2022, this is 2022. Oops. But you know how they are with Fulton County and names and looking up previous cases. We should just be happy that they didn't stick in some extra cases.
You can talk to Michael Carlson about that.
Hey, Idiot Wind.
Question. I didn't get a Jackson Deno motion. I don't know if Mr. Tuitt said anything at all to the police, but if he did, we need to vet that in advance if either side wants to use it. So I'll start with you, Ms. Fegan. Is there something you're trying to keep out from any interaction Mr. Tuitt had with the police? My understanding is he was arrested about a month later, and the arrest was confusing. The address I was going to have the jury learn more about was actually some hotel near the airport. I thought that was the incident location. That's where he got arrested. I now know what the incident location is. But any statements from Mr. Tuitt?
Yes, Your Honor, there is a statement while he was in custody, and he had Miranda read and he did.
Okay. Was it right there on the spot? So it's body cam, or it was your classic, we have him sitting in the interview room and then the detective comes in and they talk and it comes out?
The latter.
Okay. And you have a copy of that?
Yes.
Okay. And your review of it is that there really was nothing to challenge because it was a pretty plain and proper Miranda presentation from detective whomever?
Yes.
Okay. Mr. Abatte, do you plan on using anything from Mr. Tuitt's interview with the police?
Undecided. Of course.
Now, I have a problem with this because you gave the court an estimation of how long your case is going to take. And if you're going to play an interview with the police, even if it's kind of short, you're probably still adding another hour onto your trial. And an hour might not seem like a big deal when you're dealing with a 170-day trial, but when you're expecting a 2.5-day time frame, including opening and closing, where your case in chief is only going to be 2 days, adding another hour, adding another witness, having to lay the foundation for that witness to come in and then play everything, plus all the Fulton County tech issues, you should probably know. You should probably know because this is starting tomorrow. This hearing was last week. I think it was on Thursday. You should probably know. And I don't think that you're unprepared. I think that you're trying not to show your hand.
Okay. Non-committal is fine. Can you get me a copy of the interview? Because I just want to watch that little segment of the Miranda piece because I might want to get on the record that I reviewed it and I find that it comports with the requirements of Jackson v. Deno. But I hear you, Ms. Fegan. I appreciate not filing a motion when there's not a good basis to do it. Last question I've got. There's also not in the docket any business record, hey, we're going to get in phone records or this or that, and we have an affidavit from a custodian. Were you planning on getting in any business records through the business records exception? No? Okay, then that's probably why there was nothing in the docket. Anything?
I didn't catch that. That's actually really interesting because the little bit that I know about this case is I think it took a month for them to arrest him. And I don't know the context of that. I still don't know if it's a month to arrest him because they didn't have a suspect or a month to arrest him because they couldn't locate him. So I'm hoping we'll get that context through the trial. But if it's the first where we didn't have a suspect until a month later, and now we're hearing this question about like, you know, I don't see anything about you wanting to bring in a records custodian for cell phone records. I don't know if McBurney is just asking that generally because the type of judge he is, he could just be asking that generally. Or if he's asking that because, hey, something in here, there's details about you use cell phone records to locate him somehow, but yet you're not going to present that to the jury. So that's interesting. That's like making my feelers go off. like, yeah. And it's making me lean to maybe they didn't have him as a suspect at all until a month later. Suddenly he's a suspect some way, somehow.
Anything else from the state? All right, Ms. Fegan, anything we need to talk about from your side? Mr. Tuitt, because you're in custody, when you leave the courtroom, you go through a door that the jurors are going to wonder what's back there, what's going on. And so I need to clear the courtroom anytime you need to take a break. We will take during trial plenty of breaks. And so I'm not particularly worried about you saying, wait, I need to use the restroom. Today with jury selection, It's a little bit of a forced march. It's not fun for the lawyers because we don't take a lunch break. We basically break in between each panel of 17 jurors, and that's a long block of time. I say all that because that doesn't mean we can't break if you need one. It's a different kind of break. If Ms. Fegan just needs to pop back and use the restroom, that can happen. Same with Mr. Abatte. But if you need a break, I need to know to let everyone out. So tell Ms. Fegan, and she'll let me know, hey, this would be a good time for a break. My experience is that breaking after each panel is enough for a defendant. And each time we do that, you'll get to go back into the holding area. But like I said, I don't mean to impose my break on what your schedule is. So both today and during the trial, if you ever need a restroom break and we're not hitting the break for you, I need you to let the lawyer know. Okay. All right. Then what I'm going to do is ask one of the deputies to take you back to lockup, and we'll just be on hold until the jurors get here. Okay. Okay. Thanks.
I don't think we really saw much
Do you need
else.
Deputy Gordon back, or can you get Mr. Tuitt? You'll get him back? Great.
Let me double check, because I had this playing in the background while I was working on stuff. And not for nothing, but I can imagine if they had this dead time for like 20 minutes and then they came back and did something, I might not even have registered that they came back. So let's double check before I just assume. There's some motion here. Okay, so the defendant's back out a little bit here. And I don't know, I just know Rivers, Miss Rivers' last name. And I tried to do a quick search on the DA team panel on their website and didn't see anyone with the last name Rivers. So I still don't know her first name.
Ms. Rivers, you ready? All right, we're back on the record in State versus Tuitt. Deputy Gordon, it's my understanding that the jurors are already outside. All right. I need to get on the record a little incident that happened while we were waiting. The young lady here in the back of the courtroom was filming the jurors out in the hallway. Deputy Gordon noticed that and confiscated her phone. Deputy Gordon, have you, with the assistance of this person, been able to double delete whatever was recorded? Okay. Ma'am, it is not legal to record in the courtroom or the courthouse without an order from the court. That's how WSB gets in here, and that's how you as a content creator would be able to film what's going on. I'm going to assume you didn't know that you weren't supposed to do that.
Girlfriend, but she told me she's coming up there later, so I just want to get her outfit. I never met her before, so I apologize for course.
Okay, well, I appreciate the apology. While you're in the courthouse, you can't take any pictures or film or record, and that's true in the courtroom as well, unless you apply for permission. And if the judge, that would be me, said yes, then in the courtroom, you could record things, but not outside the four walls of the courtroom. There is going to be a live stream of the trial when the trial is up and running, and you're free to use that in whatever way you want to use that. But you can't be recording. So I'm going to have the deputy give you your phone back, and I'm going to ask him to have you stay out of the courtroom for jury selection. And we'll revisit if you want to come back on Monday. Monday is when the trial is actually going to start. Okay. Any questions about any of that?
No worries.
Okay, I'm glad there are no worries. Deputy Gordon, if you could, does she already have her phone back? All right, then you're good to go, ma'am. And Ms. Fegan, on behalf of your client, he is, of course, allowed to have anyone and everyone in the courtroom. I don't expect any issues, but they need to not be recording things either. All right, Mr. Abatte, the jurors are here. I'm ready to have them come on in. Anything we need to talk about before then?
No, the jury paperwork, whatever.
I think it's coming. We certainly won't start till you get it. Ms. Nelson seemed to have some of it in her hand. So before you do that, though, let me see if there is. Yeah, why don't you guys move around, and Ms. Fegan, if you will, when Deputy Gordon comes back, he can move that monitor to the floor so that it's not in your way. But Mr. Tuitt, the folks you're going to be interested in are going to be sitting there and in the jury box most of today. So you'll actually be on the back side of the table, but I'll have you come around before they get in here.
Right. I don't think they show us this because there's only a little bit left, so we don't get to hear voir dire. We just watch them play musical chairs. This looks so awkward. They got like the podium here. It just seems so backwards. And why is it? This chair's got the... They got like the standing wooden chairs. They got the rolly chairs going. I'd run in here and take this chair as a juror.
Do I have a quick moment for the restroom?
You do, if you want to hit the jury room, no problem.
All right, yeah, so they don't show us much of anything. So we'll wrap this one up.
This is all.
Again, this pretrial hearing, this was, I think it was Thursday. It could have been like Wednesday or Friday. But it was the final pretrial hearing, and trial kicks off tomorrow morning, 9 a.m. So come hang out, come watch it. And it's supposed to be real short. It'll be over by the end of the week. Unless we just call a million more witnesses, you know, who knows? Who knows? I shouldn't take it fully at face value, what Abatte's promising. But still, he thinks he'll end Wednesday. Even if it goes through Thursday, we should probably be looking at a Friday wrap-up at the latest. Also, we have Idiot Win says, you know, the last 2 lives. And, you know, so Kyron Lacey, we looked at the Kyron Lacey story yesterday. An extremely tragic outcome. You know, Lacey took his own life the day before his grand jury hearing was set. And I'm hearing, you know, that the DA expected to go in there and not get a return of a true bill. To me, I don't understand why, if that's the case, why you'd present anyway. Maybe there's some benefit of having the public decide, so the optics are off your shoulders for not bringing charges forward when, unfortunately, Mr. Hall, also a victim, you know, he was killed in a collision that, quite frankly, didn't involve Kyron Lacey at all. But Kyron Lacey was the one that was about to have a grand jury hearing for it. So maybe the district attorney's office said, hey, you know what? We don't want to look like we did nothing about the tragic loss of life for Mr. Hall. But we're going to put it in a grand jury's hands, and we're going to give them the report that says the things that, you know, we don't think that Kyron Lacey was responsible, but we want the grand jury to say that and decline to return a true bill. So I don't really know what was going on with that, but, you know, tragic stage of the proceeding. It was really something to watch the attorney fight. Like, the attorney did this 45-minute interview where he very well laid out all the details and why this was just bullshit against his client, Kyron Lacey. And he was fired up the whole time. And then at the end, it's like he got stumped when he was asked the question about the timing of when Kyron Lacey took his life. And all I could feel in that moment was that this attorney felt like he, no matter how much he was doing for somebody, he has guilt, feeling like he didn't do enough. And that really, really, really hit me. And I've seen since social media posts from Kyron Lacey's mom, where she's just making a general plea to, you know, other mothers, other fathers, people with children, people that work with children, you know, to not be afraid to poke and prod a little bit more when someone's giving you the, I'm all right, it's cool, I'm fine, you know, don't feel like you're bothering them, try to go the extra mile. So like, I just the guilt all around that the family members, the attorney are feeling because this whole story unraveled where, in my opinion, my view is, woman was not paying attention while she was driving, almost hits the car in front of her, veers, unsafely hits another car, and Mr. Hall is killed in that process because he's in the vehicle that this driver collides with. She tells a bullshit story when she's in the hospital. I don't know why the officer, it seemed like everything was aligned for the officer to realize she was lying. But they didn't go there. They kept asking, what's with this green Charger? What's with this green Charger? I don't know if they assumed that this green Charger belonged to a teenager, belonged to somebody that was about to go to football practice, because football practice was happening that same day. That's where Lacey was headed to. I don't know if they knew that Lacey was a driver. This officer just wanted to get this sports car. And he let another witness, the truck that was in front of the woman driver that actually collided with the vehicle and killed Mr. Hall. Officer just was like, all right, you were eating your Funyuns, no big deal. No big deal, you were doing over 50 and then 49 miles per hour where the speed limit's like 30. No big deal that you only hit your brakes. We were going to have this other guy say he had to check his brakes because he saw somebody in oncoming traffic in his lane. Say the green Challenger. Even though that witness is like, no, it was the lady behind me. She was driving too fast. She had to pull around me from behind because she almost hit me. It just a disgusting approach to a case. Just a disgusting all-around thing. And then on top of it, Kyron Lacey takes his life. And there were people on social media saying, you know, why would he take his life if he didn't do it? And I don't live in the area. I'm not part of the prosecution team. I'm not a defense attorney, but what I can do is advocate for us to have a better sense of understanding why people might do things and react in a way that might not seem consistent with what we think we would do if we were in that situation. I think we need to be understanding of people being angry when they're falsely accused. People being silent and in shock when they're falsely accused. And that anger, being in shock, falling into depression, having a complete disruption of your mental health. If those things happen because we're dealing, and it happens in the civil litigation world too. It's not just criminal accusations. It happens with civil litigation too. If we see somebody have a downfall or decline after being accused of something, that downfall isn't just automatically karma because they actually did the thing. And we have to stop looking at things that way. Because in this case, it drove someone to suicide. And he's a high-profile person. I'm sure there's people out there that just because their reputation is harmed among their family members, their friends. Here with Kyron Lacey, social media, it was all over. Viral story. But what we saw Kyron Lacey deal with and go through and the ultimate outcome of it, I think happens to people in silence too. Where we aren't aware that that's happening to people. And it's really not right to just assume, oh, look at their body language. The only explanation for why they might have raised their voice here is because they're a bad person and they're guilty and they're dangerous and they're whatever the social media discourse turns into. And it really sucks to see. And then I think the second to last trial was that the lyrics, the overturned case with the lyrics? That one, I was happy to see that just because the judges in that, they wanted to make a ruling in the interest of justice. It wasn't just pertaining to, the facts of this case. They're like, you know what, this one issue alone probably wouldn't even warrant a new trial, but cumulative, all these errors together, we think they had a cumulative effect and that he was denied a fair trial, so give him a new one. But we also want to note that we think this whole lyrics thing is a bit ridiculous, and we don't think you should be able to call in somebody, that we think the judge's decision to tell the prosecutors you have 10 minutes to pull someone in here as an expert on slang and then not properly qualify them, we take issue with that. So it wasn't a full-on blanket bar on the use of lyrics in trial, but pulling in an investigator from the prosecutor's office to throw them on the stand and have them interpret lyrics to mean exactly the thing that would support your theory of the case, court said that's a no-go. And that was a New York case. So that was awesome to see. And again, whether that defendant who's going to get a new trial did the thing or not, let the jury get there without somebody getting up there and saying, yeah, you know what, this is what we think these lyrics mean. We think it means exactly what the state wants them to mean. So, yeah, Sheriff Chuck, I was falsely accused and charged with a crime. It is traumatic and depressing. I hate to see it. And there is never a full clearing of a name. I don't know one single example where somebody has been accused of something and it goes away. An exoneration, a full exoneration by law, right? The courts are like, you're in the clear, sir, ma'am, you're in the clear. You're exonerated, sure. But it's not a reset button. It's not a reversal. And one of the most like bittersweet, beautiful things is these individuals that when they are falsely accused, falsely convicted, and like they get the worst luck of the draw when they're falsely accused. They're incarcerated for decades. They lose their life. Kids are 2 years old when they go to lockup, and they're coming out, and they're kids that they didn't see through their whole upbringing because they were wrongfully incarcerated, are full grown with families of their own. They're meeting their grandchildren for the first time. You know, what's really crazy incredible to me is those individuals come out, and I've seen it over and over, so many different stories. They're like the most optimistic. Like, it's so admirable and so honorable. And I can't imagine not falling into a deep depression if I was in custody for something I did not do. And to imagine like how somebody can be so powerful and so, I don't know, so humble when they've been done wrong, to come out and just have one of the best mindsets. It astonishes me every time. Exactly, Mara. And I mean, like, maybe it's how you get through it, right? I just can't even imagine. I've been falsely accused in friends groups, right? You know, drama. People get the wrong impression of you. They make up things about you. I've dealt with like dirty cop stories with traffic citations, right? You know, ran over the curb but pulled too far into the left lane at the same time. That doesn't make sense. And then it gets dismissed, right? It was a stressful several months. It was just a traffic infraction. It was aggravating, but I didn't lose my freedom. But even that small thing, that small infraction pissed me off. So I can't imagine what it's like to be accused of something egregious and then convicted for it and punished for it. So, Sweet Lady Sugar, good to see you, says, James Bain from Florida did 35 years, falsely accused. Innocent Project helped free him. And that's the crazy part, you know, Innocent Project, not only, you know, their intake's a bit limited, but they heavily focus on having, you know, DNA evidence, new evidence. And that's a key part of their motions, right? They look at DNA evidence that hasn't been looked at previously. And that's cool. That's a very powerful thing to look at. But the secondary aspect, the strength in looking at DNA evidence, is when you have new evidence to look at, that gives you a vehicle to petition the courts after the regular appeal process has run its course. That gives you a mechanism, a vehicle for you to file a motion and say, hey, look, we need a new hearing. There's evidence that could change the outcome, and it's never been heard in a court before. It's never been heard by a fact finder. So we need this hearing to determine, we're going to request the opportunity to be heard and have a new trial with this new evidence. So that DNA evidence, the DNA evidence can speak for itself and go to the innocence of somebody that's been convicted. But it also gives that new mechanism, right? Nope, you've exhausted your appeal avenues. No, wait, we have this new evidence. So really, really important. So, oh, okay. So Aaron says that's just the main Innocence Project. Lots of Innocence Network affiliates don't require DNA evidence anymore. Thank you. And honestly, the Innocence Project Network and who's affiliated, what's a local syndicate, and how loosely or tightly affiliated they are confuses me a lot. It's the same way I look at Supreme and Superior Courts in New York State, and how Supreme is not not the Supreme Court as we know it in other states. I want to find, there is a, let me find, there is a Facebook group called NYS Department of Corrections Federal Oversight. Main topic in there has really been the Brooks murder trials and plea deals and the development of that case, those cases. But there's a lot of other things that are shared in there. I'm going to link to a group. It is a private group, and I am not going to share necessarily what's in the group, but as far as I know, they're open to people joining. The reason they keep it private is because people do share firsthand experiences. If they hear something is going on in a particular facility, this is the block that it's happening on, call your loved ones, make sure they're okay. So they keep that private just so that isn't getting trickled out and blasted everywhere. But a lot of information that is posted in there to share for people that are interested in the same things. And one of the things, let me get it separate so I can show you guys. I thought was really cool to see, and I wish I was back in New York for something like this, because post-conviction work advocacy, I feel like, is a growing field. It's a growing aspect of legislation. Bills are being passed that hopefully are trying to give a little bit of something to protect those who have been wrongfully convicted or their family members. But there are issues. There are post-conviction integrity units. There are conviction integrity units being set up in different localities, and reports are coming out left and right. You know, we've got stories in North Carolina where their conviction integrity unit is really like, ball is moving. They're overturning convictions. They're going through case files. Seems like they're being productive. New York, there's been reports of terrible productivity for the conviction integrity units across New York State. Something, just general recall here, like, 800 applications, but they only reviewed 5 or 6 and then took one forward and didn't even end up overturning it when all was said and done. So people are taking issue with the funding that's going into these programs for there to be no action. So I had seen this. I think it's interesting if you guys notice anything going on elsewhere in the country. There is a protest that I saw shared to the New York State Department of Corrections Facebook group Wednesday, October 8th at 1 Hogan Place. So I believe that's the Manhattan courthouse, the main Manhattan courthouse. Wrongful conviction survivors demand justice from Manhattan DA Alvin Bragg. So it's saying keep your promise. So this is in relation to these conviction integrity units and their failures, their inaction. They're just taking up funding and nothing's actually coming from it. So I thought it was really awesome to see the call out. But yeah, keep an eye, that's a lot of funding. It's big promises. It sounds good. But if you're not actually looking at the cases, what are you doing with those resources? So there's that. I think that wraps it up. Let's see. Yeah, that guy Nick says you have to be optimistic. You don't hear from the pessimistic ones. That's a really good point. That's really, really sad to think about, but I think it's a good observation. And then you said you're rightfully put in jail and haven't committed a crime because of losing your freedom is terrible. And I actually do, I think deterrence works in some way. But I don't think deterrence can work without a sense of humanity. I don't think deterrence can work without a sense of humanity. Because if you, philosophically speaking, if I do something wrong and I feel like, I get a punishment for the thing that I did, yeah, I might be embarrassed. I might be ashamed. But if I feel like it's proportionate, it is what it is. But if you treat someone inhumanely, disproportionately, unfairly, you're creating spite, you're creating resentment. Those things that you're doing to treat them unfairly might pragmatically be causing them a loss of work, loss of their living space, loss of their income. All of those things start building up where now you're creating, it's like you want to create your own Frankenstein monster out of somebody. You take all the good pieces out of their life to deprive them of something because they're accused and you want to just throw the book at them. So, Brooklyn says there was a big settlement from Rikers Island with anybody that was there in the West facility receiving $500 per day during COVID. Oops. And, I hope taxpayers, if you don't like your tax money going out in settlements like this, you can't blame the recipients. Blame the ones that caused the suit in the first place. So, and I think we're still seeing, let me look real quick if there's been any updates. Okay, so I don't see any immediate updates on the Tiriana Ledbetter situation. Guys, Tiriana Ledbetter, I mean, the story really came out this week. But at the end of September, like September 22nd, Tiriana Ledbetter, she was an inmate in Fulton County Rice Street Jail. She had a cellmate. They both have mental health issues, and both families are taking issue with the Fulton County Jail, not making sure they were housed correctly, that they weren't housed separately or in proper areas because of what their conditions were. Well, I think Shania White is the cellmate that beats Tiriana Ledbetter to the point where she's now on life support in a hospital. And the family didn't find out about it until they saw, I think the victim's family, Ledbetter's family, they got a call from like a non-jail facility. It was like somebody that heard about it and gave them a call. And then Shania White's family found out about it because they saw on Fox Atlanta was covering the story. That's how they found out about it. And, the victim's family, I mean, the Shania White's family is extending their sympathies to Ledbetter's family. I think it's nice to see. And then the Ledbetter family is like, our relative's on life support and you didn't even notify us. Can you imagine if your loved one passes away and you had maybe like a week to go spend time, but nobody lets you know? And when you're in custody, you're a ward of the state. State's supposed to be responsible for you. States should be informing next of kin of matters like this. Especially when you're incapacitated because you're on life support, your next of kin should be informed. Because what if vital and critical decisions need to be made? So, I'll be keeping an eye on that. I mean, maybe there's been an update if I dig deep and look and check on Facebook and see if the family's saying anything. But as far as news coverage, I don't see anything about an update on her condition over the last few days. So hopefully she's off life support and doing better. But yeah, that's Rice Street. We're back at Rice Street with that story. So when is change going to happen with the Rice Street facility? And are they going to decide finally once and for all, just rebuild the facility? And what's the pragmatics of that going to look like? I don't know if I can imagine them handling the transfer of all the inmates currently housed at Rice Street to other facilities and that not being a whole cluster. But doing nothing is clearly not helping people here. So let's see. We're getting into heavy topics again. I think James Phipps, I think this is really the crux of it. Taking the profit motive out of the prison system would be a good start. Yeah, and there's, for publicly owned facilities, it's one thing. Then you have the private facilities where it's more directly heads in beds, right? We want to put heads in beds. We get this much funding per day if these beds are filled. So we want that funding. That evolving that system, I think, would work wonders and is the correct place to focus. So, and then Aaron, will end on this. Aaron shared a bill in the chat, you guys, that's going to be effective on January 1st of this upcoming year. And it will relate to a component in Georgia for compensation for wrongful charges. So Georgia's a little bit behind on that, it seems like. But again, a lot of states are catching up on relief in the post-conviction space. Alrighty, so I'm gonna thank you, Aaron, for linking this. This is a bit lengthy, you guys. It'll be in the chat if you want to read it, and I'll update the video description. But it is good to see states putting forth legislation that recognizes and tries to do something about the impact of wrongful incarceration. Because again, in a lot of states right now, you're wrongfully incarcerated, all right, we'll exonerate you, but you're on your own when you get out. So what if we've robbed you of 30 years of your life? Go out there with your little check and your belongings from being in custody. There you go. I don't know who's streaming right now, you guys. Who do we want to redirect to? And we'll be live again. We'll like 9 in the morning, you guys. If I see that McBurney's court isn't starting till like 10, we'll start whenever McBurney goes live, but I think he starts right at 9 Eastern. But I will be here with my coffee, ready to go. And right, redirects. We gotta tell people to stream on Sundays. The redirect, we've got yeah, like nobody's coming up. Let me just search trial and see who's live. Yeah, it's just giving me like upcomings for people that are doing things tomorrow. So let's see if Dolly Talk has a stream scheduled. Dolly Talk, I think every weekday. I think it's straight Monday through Friday. This is going to link to the 7th. It's pulling up his stream scheduled for the 7th, but I do think I saw him scheduled for the 5th. It'll take you, he's not going live right now, obviously, but he does courtroom roulette where he hops around different courtrooms. Like you heard McBurney say on Wednesday, they're doing drug court. So those types of proceedings where it's like arraignment, pleas, bing, bang, bong. His channel rotates between different courtrooms around the country and shows those kind of rapid paced cases. So really fun to watch, really interesting to watch the day-to-day court proceedings. So this will link over to a scheduled stream, but you can hit that subscribe button or like to catch it when he's actually live. Yeah, we're gonna watch football. My game's over, guys, and I feel so bad about the Kyron Lacey case because word is the Vikings are really looking at him. So today when the Vikings went to play, I'm thinking about that case again. So Vikings are my team. But now it's bittersweet today thinking about everything we learned about yesterday. Someone that could have been, a role model out on the field. I'm not going to be that person, FFS. I need some free weekend time to catch up on breathing. And thank you, Aaron. Thank you. I will go check out their directory because I see all these little accounts somewhere. And sometimes I even see comments that it's like, this is not affiliated with the Innocence Project. And it gets very confusing. So thank you, Aaron. Yeah, and if they stream on Sunday, we won't have to be in the bushes so much. Oh, and guys, it's also AV to the 7th Power's birthday today. So if you're looking for something to check out, go hop over to one of her. She's not live or anything. But it is her birthday. Hop over to one of her past videos, check it out, and leave her a comment. But it is her birthday today. So there's that. I think we got everything, you guys. So see you tomorrow. I will throw this in the description, and everything else should already be in the description. And then we get to watch Nicole Fegan in action at trial, not just a pretrial. Adam Abbate, I know you guys are like, oh, do we have to? Yes, we're going to watch more Adam Abbate. We're going to get Judge McBurney, and we're going to learn more about what is this case about? Murder case, Cordarra Tuitt. I don't know much else yet. I'm going to kind of just be a juror going into the particulars of the case. So see you guys tomorrow morning. Definitely looking forward to it. And everyone have a great rest of your Sunday. Bye, guys. And we'll end with the tomatoes for a